only one allowed by grossly abused. Our governors have to share police powers with the president as stipulated by the Constitution. We do not have a federal government police force. We have the Nigeria Police Force, which shall be administered, organized, and supervised by the Nigerian Police Force.
No, my lord, I want to say something. I want to say something here. Perhaps it might also enlarge the scope of people who should be invited here for examination. My lord, if we cannot find those who literally murdered Abiola, who are those people who could be said to be the beneficiaries of the death of Abiola?
Rogers has linked you with some of the killings he did.
He never did.
He linked you with the attempted murder of Hebrew.
He did not.
My lord, the matters council is leading the evidence in our matters.
Is this an adversary proceeding?
It's not, my lord, but we can't be talking about cases which are in court.
Is this an adversary proceeding?
It's not, my lord. These cases are in court, my lord. I'm just reminding your lordship.
My lord, sorry, my lord, I think I'll be in cross-examination.
Legally Speaking, a program that deals with legal issues and questions we face as citizens of this amazing country, Nigeria. Legally Speaking. Join us every
Friday from 5 p.m. to 6 p.m.
for Legally Speaking.
All right, good evening. You're welcome to this Friday edition of Legally Speaking on Planet Radio 101.1 FM and Spectrum TV. My name is Anthony Ebuk, and well, today's edition is going to be a unique edition. A unique edition in the sense that we are starting solo. If eventually my guests come in, then they will join us, and that will be much later in the program. All right, today's topic of Legally Speaking, we'll be talking on two issues. We major first on landlord tenancy issues. Now, these issues has plagued Nigerians, and not just Nigerians, other nations. How do landlords relate with tenants? How is it that in Nigeria the tenants appear to be having the upper hand when it comes to relationship between landlords and tenants? I'll open the phone lines from the beginning of the show in case you want to call in, you have a question you want to ask, you can ask and make your contributions. So the numbers that you will call will be 090-222-31011. I repeat that number, 090-222-31011. You'll also call the alternate number if this doesn't go through. That's 070-454-17707. So I'll start with landlord tenancy and then probably go to the family court issues subsequently in the program. All right, on landlord tenancy issue, who is the landlord and who is a tenant? The landlord will be one who owns property. The property could be bare land and could be a built-up property. And the property could be of any dimension, could be on a lease, in which case the tenancy period is more than 2 years. It could be on a tenancy, in which case it's less than 2 years, 2 years and below. All right, so a tenant is a person who takes the offer of the landlord on a property, an empty property, to possess for a period of time. Now, this period of time could be 1 year, could be monthly, it could be daily, or that's, yeah, in terms of hotel, yes, it could be daily rentals. But there is a law that governs them. This law is supposed to regulate how they relate and ensure that there is peace between the two parties. One of those such laws is the landlord tenancy law of Akwa Ibom State. I want to zero into Akwa Ibom State, at least this is our base. Every other state has their own landlord tenancy laws, and they have their peculiarities, but they are generally similar in nature. How do I mean? Now, a landlord tenancy relationship is such that the law expects that where one takes up the other's property to possess, he is entitled to peaceful enjoyment of that property. Beyond being entitled to peaceful enjoyment, he is also entitled to, most importantly, notice to vacate the property when it is due. All right, and that has always been the bone of contention between landlords and tenants. A tenant would say, my property, okay, the property I took from him, I'm still in possession of the property, I'm still in advance of rent, but the landlord has issued me notice to quit. Why would that happen? I receive a lot of such complaints from time to time from tenants. All right, the landlords also have complaints. Part of their complaints is this: I am in possession of the property. Okay, my tenant is in possession of my property. But doesn't allow me access to the property. I come to cut plantain, he wouldn't allow me cut my plantain that I planted. You know, and there are some plumbing works to be done. I hear he does this or that. He's turned my house into a brothel. A lot of people come in and out of the property. My toilet is going to get filled up soon. They soak away. And they want your advice. All right? I want him out of my property. He insulted my grandmother yesterday, especially where the landlord lives in the same compound with the tenant. So these are issues you find that comes up every other time when there's such relationship. So in Nigeria, or in Akwa Ibom in particular, this the landlord tenancy law, and there is also the rent control law of Akwa Ibom State. The rent control law of Akwa Ibom State basically looks at the relationship between tenants in residential areas. All right, the landlord tenancy law also includes tenants that are commercial in nature. All right, so if you go to court, you find out that the rent court takes care of matters that borders on tenants that are in residential properties, whereas those in commercial properties, the law that governs them is the MU, that's the magistrate court rules that govern them. Okay, so what are the major issues that you find with the landlords? The landlord wants his property to be prim at the end of the day. So you see sometimes in a landlord tenancy agreement, they say you must leave it in tenantable quality. That means if you are leaving my property, return it to the state it was when you came in. You might have to repaint the property. You might have to change some locks that were bad. You might have to change some fittings like bulbs. It depends on the agreement between the landlord and the tenant. So, what agreements did you enter into with your landlord? All right? Those are the things that will be used at the end of the day to determine how you vacate the property, whether you vacate in peace or you vacate in pieces. And as a matter of fact, I've seen tenants vacate properties in pieces. They broke all the bulbs, cut all the wirings and the plumbing work, locked the door and left, only for the landlord to come in, and even went ahead to pour engine oil on the floors, the walls, and the ceilings. I don't know what really happened, but the landlord went in after taking the keys from the tenant to discover he has wrecked the house. And this is not the kind of relationship the law envisages in such landlord tenancy agreements. All right, so we start again. We go back to the commencement of that relationship. At the commencement of a landlord tenancy relationship, we erroneously think that a landlord tenancy relationship naturally commences when a rent is paid. So when the rent is paid, an agreed rent is paid, then we have a relationship. Now, in law, the law would require that you have a written agreement on what should govern you. All right? Over time, we've come to understand that what governs that relationship is more of the agreement of the tenant, not even the law. The agreement of the tenant supersedes the law in landlord-tenancy relationship. So when it is written down, then we are good. But when it is not written down, then it does not supersede. The law then supersedes. All right? Now, a man comes into your property on the first day of January 2023. There's an expectation that at the last date of December 31st, 2023, he should vacate your property if he's a single term tenancy, that's 1 year tenant. All right? Now, the landlord is not expected to give him any notice if there was an agreement that states that he is a single term tenancy. All right? So at the end of that 31st, if he doesn't leave your property, the landlord is expected to give him 7 days notice of owner's intention to recover possession from him. You are supposed to leave on the 31st and you are still here. What are you doing? Please vacate my property within 7 days. And when he fails to do that, then you invite the court to evict him by filing a plaint in court and inviting him to come to explain why he shouldn't hand over possession and pay you for the extra period he has stayed in the property. But that's what I've described is about a single term tenancy of 1 year, right? You could also have a single term tenancy of 2 years. Those kinds of tenancy don't require notices to terminate the tenancy, because from the inception of the tenancy, the landlord knew when he requires his property back. The tenant also knew when the property is expected to be handed over. All right? Okay, fine. Now, there is another category of tenancy. That is the yearly, monthly, weekly, daily tenancies. Okay? These are the categories of tenancy that require notices. All right? All right. Let's take, for instance, I'm a monthly tenant. The law expects that as a monthly tenant, if the landlord no longer requires my presence, the landlord must notify me 1 month to the end of that tenancy. All right? Okay, let me explain this other way. In monthly tenancy, activates itself automatically. So from month to month, January, at the end of January, that tenancy activates itself for February. At the end of February, it activates itself for March, with or without the payment of rent. The payment of rent is of no consequence. The agreement activates itself. Now, where the man is in arrears of rent, or the tenant is in arrears of rent, the landlord is expected to court and claim for his arrears of rent. Okay? But if you want him to quit, you cannot ask him to leave because he has not paid his rent for February. All right? So what the law expects is that every time you have a tenancy, you write what is called an agreement. That agreement will determine whether this person is a monthly tenant, a yearly tenant, or a quarterly tenant. All right? Okay, let's assume that you are a monthly tenant. As a quarterly tenant. As a quarterly tenant, the expectation is that every 3 months you pay a new rent. Every 3 months you pay a new rent. All right? And that rent will be agreed upon. Maybe you lump the 3 months rent and be paying them at every quarter installmentally instead of paying a 1 year rent, at the convenience of the landlord, at the convenience of the tenant. All right? Some people will prefer to pay their rent in 6 monthlies. So at the convenience of the landlord, if the landlord is agreeable, the kind of work I do will not allow me bulk money to pay you 1 year. So I bulk for half a year and be paying you at half a year's instance. Very well. At that rate, the expectation by the law is that if the landlord wants the tenant to quit, that half a year tenant to quit, you give him half a year's notice. Very simple. So he knows at the end of this tenancy or the next set of tenancies that he'll be out of your property. All right, I'll pause here to remind you that the phone lines are open. We've opened it from the beginning, and the numbers to call is 090-222-31011. The alternative number to call will be 070-454-17707. It's a holiday edition of the Legally Speaking, and I'm flying solo. So you're welcome to have at least keep you company on the 1 hour run. All right. So we are talking landlord tenancy issues right now, and we have been discussing issues surrounding monthly, daily, and weekly tenants. At least that's the current position we are. We've already discussed single term tenancies, and now we are talking about tenured tenancies. Fine. So for a tenancy that is annual, that's a 1 month, a 1 year, yearly tenancy. What is expected of the tenant or the landlord? Let's start with the landlord. What is expected of the landlord is that at the end of every year, that tenancy activates itself automatically. It does not require any action from the tenant, does not require any action from the landlord for that agreement to be activated. Right? So, year in, year out, whether or not the tenant pays rent, if you notice, I've been emphasizing on that. Whether or not the tenant pays a rent, he is expected to continue his tenancy. Where the landlord is of the opinion that the tenant should not continue the tenancy, what the landlord does is that before the last 6 months of the tenancy, you issue that tenant a notice that says, at the end of this tenancy regime, you'll be expected to deliver up possession of my property. All right? So, I think 6 months to that is June. All right? So, about that period, ensuring that it is not less than 6 months. You issue and serve on the tenant a 6 months notice to quit your property. That 6 months notice should at least terminate on the 31st day of December, if it's a yearly tenant that runs from January to December. So, as at that December 31st, it's no longer your tenant. That's the if of the tenancy. At the end of December, by 12 midnight of December 31st, he's no longer your tenant. So you're addressing him not as landlord tenant, but as owner occupier. So when you're issuing a notice after that December, you are addressing the landlord as the owner of the property, which is why we call that notice owner's intention to recover possession of his property. That means I don't have a relationship again with you. You're no longer my tenant. You were my former tenant. Now I am the owner of this property and I want you to hand over possession of the property to me for whatever reason I want it for. Whether it's for my personal use or for a new tenant who is willing and ready to pay rent and occupy the property. All right. So people always ask, how come my rent is on credit and the landlord is issuing me notice to quit? The answer is very simple. Rents and agreements to stay in a property are two different things. The rent is part of the covenant of the relationship. It's one of the covenants. For instance, the landlord can say, you cannot sublet my property to another person. So if he sublets your property, you can't just quit him. You have to go to court and say, my lord, this tenant has broken one of the covenants of the tenancies, has brought in a third party without my consent. Please, these are my reliefs. And the court will grant it. Same thing goes here. If you are being owed a rent by the tenant, you can't just ask him to leave the property. You have to go to court and say, my lord, this person owes me. I'm entitled to a certain amount of money on a monthly, daily, weekly, yearly basis. And as much as this, as of today, this is what is outstanding. That have not been paid to me. I need my money and I need possession of the property if you need possession. It's not compulsory that the two must go hand in hand. So where that happens, and where a tenant owes you rent, and you feel because he owes you rent, you should vacate your property immediately. That's the problem we always have in our state. Because the tenant will not want to vacate, and the court will support him on that. That misconception of the need to pay rent as a sine qua non for staying in the property is where we all always have it mixed up. All right? Now, today I'm telling you the position. The position says rent is an important aspect of the agreement. It's a live wire of the agreement, but it's not the only reason for the agreement. The landlord wants his rent, very well. But there's a document called tenancy agreement which you had signed with him that says, before I leave your property, these are the conditions. And the conditions will include that I give you a certain notice, a period of notice before I leave. Now, why did I say earlier on, recall, I said earlier on that the agreement of parties supersedes the law in some instances. This is what I mean. Where the law says, in the absence of any agreement by parties, a yearly tenant, that should be section 15 of the rent control laws of Okwara State. It says that in the absence of any agreements between the parties, a yearly tenant is entitled to a 6 months notice to quit. A quarterly tenant is entitled to a quarter's notice to quit. A monthly tenant is entitled to a month's notice to quit. Now, the key word there is, the phrase there is, in the absence of any other agreement between the parties. It means where there is an agreement that my length of notice shall be shortened to 1 month as a yearly tenant and you have signed that document, you cannot activate the law that says you are entitled to 6 months notice, because that agreement has short-circuited the law. We say, well, in our own agreement, we agreed that it will be 1 month. The law is bound to bow to the agreement of parties. The agreement of parties are one of the most powerful tools in the hands of anybody in terms of landlord-tenancy agreement. So you have to be very careful what you write into your agreement. You have to be very careful what you sign in your agreement, because it can rob you and pay the other person. Okay? So, wherever you have a conflict that says, I am entitled to a certain number of months or days or weeks of notice, first you ask, is it in your agreement? Where it is not in parties' agreement, what do you do? Well, except there was no agreement. If there was an agreement, you're bound by it. If there was no agreement, then you have recourse to the law. What does the law say? What term of tenancy am I enjoying? Is it a yearly tenant? A yearly tenant means sometimes it can be inferred. Or how is it inferred? It can be inferred when the law considers your mode of entry. You paid a 1-year rent. The law assumes that you are a yearly tenant. If you paid a 1 month rent, the law assumes you are a monthly tenant. If you pay a quarter's rent, the law assumes that you are a quarterly tenant, and will expect that the length of notice to quit will follow the same pattern. Okay? Now, there have been recent developments in laws, and these are all ways of trying to factor in how to make that relationship more cordial. Because you walk into, people walk into your office if you're a lawyer, and they bring all sorts of complaints. My landlord came, cut my water, removed the roof, and I'm stranded. And the first question you hear the lawyer would ask is, has your rent expired? And he will say, no, I'm owing him, I will pay. Okay, if he says he will pay, why does the landlord remove his roof? Why does the landlord cut off his water supply? Why does the landlord cut off his power supply? Okay? And if that happens, what do I do? Very simple. You have 2 courses of action. 1, you go to the police. It's a criminal offense for your roof to be removed whilst you are living there by anybody, including a landlord. It's a criminal offense. It's a criminal offense for anybody to cut off your power supply whilst you are living in that house that is not PhD or a power electricity supply company. He has no power, he has no right to do that. So you can report him to the power distributing company. You can also report him to the police. It's wrong for anybody to cut off your water supply, unless you are in agreement that where I don't pay rent, my water supply should be cut off. All right? So if anybody does that, you walk to the police and report the matter, and he'll be treated like a criminal, because that's what he is at that point. As a suspect, he'll be tried in court, and if convicted, he is convicted. Okay, that's on one side. On the other side, the law also allows you to seek redress in court. You approach any court and say, I live in this man's house. It's a breach of contract for him to come in and cut off my power supply, cut off my water supply, not allow me or remove the roof in my house. You'll be surprised. For the rent that you owe, which is maybe 35,000, the court can award 350,000 for that inconvenience. And you use that and pay his 10 years rent and stay in his property forever, because he's been foolish enough to attempt to sometimes lock you out or inside your house. Because I've seen landlords do that. They come to a shop, lock it with the tenants inside. That's false imprisonment. But you see, a lot of us are not that enlightened to know that these things are not proper. So they go ahead and do them. All right. So at this point, I would like to remind the listening audience and the watching audience that the phone lines are open in case you have questions you want to call and ask. So the first number you can call is 090-222-31011. The other number you can call is 070-454-8 17707. Okay? So if you have any issues bordering on that landlord tenancy issues, you call in and let's talk. All right? Okay, so having assessed the two kinds of tenancy, or the two levels of, or I should say types of tenancy. One is a fixed tenancy, the other is periodic tenancies. I would also want to emphasize that there is this other one called the lease. All right. Hello, good evening.
Sure. I'm just calling from a private.
Okay.
Exactly.
Go on,
I
sir.
live in River State.
Okay, you live in
I
River State.
read- Yes. Now I have an issue with the landlord in the sense that the landlord, my rent has not expired, but he wants to retrieve the house. But he's telling me that he will return the rent money for me.
Okay.
To know
All right.
if it's right.
Okay. Okay. Thank you very much. Now,
Thank
his position is that he has paid his rent. He's had an agreement to stay for a period of time. That rent has not expired. The landlord wants to recover possession of that property and has gone ahead to offer to refund the amount paid. Now, as soon as you have an agreement for a year, that agreement is binding on all parties. You've paid for that year, it's still binding on all parties. What the landlord wants to do now is to renegotiate a new agreement. And you see, he cannot renegotiate on his own. He's not an authority to renegotiate on his own. It takes two to tangle in this case. And where you don't want to tangle, he cannot clap with one hand, right? The landlord has to negotiate with you to a point that you agree. He might even have to pay you a higher rent if your negotiation skills is better. He might offer you to look for a new apartment, pay for it, for you to move into that new property. Because you see, it's not just returning the rent to you. There are a lot of things that are logistics that are not taken into consideration. Anybody can have 250,000 today. But for you to move into an apartment that is as convenient as the one you were used to, it takes more than the 250,000. Because you have to consider, if you are married, your workplace, your wife's workplace, your kids, where are they going to school? Those are certain things you took into consideration before you moved into the neighborhood, right? And now there probably is no property around the neighborhood that is free. And even if it's free, it might be too small for you or too large for you. So this was maybe a perfect fit. The landlord has to consider that. Now, I'm not saying the landlord is wrong towards his property, okay? There are times you let out a property because it was empty, and all of a sudden your child wants to come back from the UK. He's done his master's, and you need the property back because that might have been where you kept for him. It informs why the landlord would say, please, let me refund the money, okay? So at this point, it is only you that can decide if that agreement will work. If you are comfortable that he refunds the money, good. You can go ahead. It's still valid, all right? But where you are not comfortable with him returning the money to you, you don't have to agree. And he cannot do anything about it. He just has to wait. Now, whilst waiting, I just hope the landlord will be wise enough to issue you with a proper notice to quit. Because he's just negotiating by word of mouth. He needs to give you a proper notice to quit, to terminate your tenancy if it was a periodic tenancy. Periodic tenancy meaning a yearly tenancy. If not, he will still run into that crisis at the end of the year. He said, I told him to quit since January. I want to refund his money. Now his rent has expired. He should leave. No. The law will require that he issues you proper notices in writing. In writing. So he can still expose himself to frustration. He can still frustrate himself if he does not do the right thing, if he doesn't get the proper legal advice and just continues to pester you. At the point he will just give up and say this man doesn't want, I'm just waiting for his rent to expire. When his rent expires, I know what I'll do. He doesn't know what he will do. There's nothing he will do. He will be required to issue due proper notices early enough. If not, he'll be caught up by the law. All right, so that's it for that question. Yeah, we're going back to what we said earlier on. There is periodic tenancy and there is a fixed tenancy. There is also the lease. The lease could be as long as 100 years. The lease could be at least 3 years. So tenancies above 3 years are expected to be in form of a lease, and leases are expected to be registered. So when you have a tenancy of probably 3 to 5 years, and that lease agreement is not registered, you will have issues. Yes, hello. Hello.
Hello, good evening.
Yes, good evening, sir. You're on to Legally Speaking.
Can you hear me?
Very well.
Okay. Okay, my name is David.
David.
I'm calling from Enugu.
From where?
Okay. From Enugu.
Enugu. Okay, go on, sir.
Okay. Regarding the yearly tenant, if before moving into the compound and the agreement was drafted between the tenant and the landlord. All right. So is the agreement supposed to be renewed on yearly basis, or does that one-time agreement remain valid for the period of years that you stay?
All right.
As a yearly tenant.
Okay, sir. Thank you very much. Now, if you enter into a property and that property requires that you or identifies you as a yearly tenant, that agreement suffices for 200 years. It runs and activates itself indefinitely. You don't need to write or sign a new agreement. That agreement activates itself. Okay? But if it is a single term tenancy, a fixed tenancy of 1 year, at the end of that tenancy, you are no longer a tenant. Now, let me tell you the other trick about it. Even if you continue to pay rent and stay in that property, the day the landlord wants to evict you, all he's expected to do is to give you a 7 days owner's intention to recover possession. So the law of 6 months notice does not apply. And you'll be stranded because he goes to court. The court will agree with him that you're not entitled to any length or longer than the 7 days of owner's intention to recover possession. So you have to be very careful when you are reading through your agreement before you sign. How am I being classified? Am I classified as a periodic tenant or as a fixed tenant? Okay. So because if you are classified as a periodic tenant, then you are good. If you are the tenant, it activates itself. You don't need any further agreement. But if you are classified as a fixed tenant, then there's a problem. If your intention is to be a periodic tenant. Okay? So you might need to renew a fixed tenancy every year. You might not need to renew a periodic tenant every year. Okay? So you have to be careful with those fine lines. They are very important. All right, so I was talking about the lease. When a man comes in and is identified, or when you take a property and you identify yourself as a lease tenant, right? Be sure that that lease agreement is registered, not just in court, but with the board, Ministry of Lands. In Akwa Ibom State, it's a Ministry of Lands. You have to take that agreement to the Ministry of Lands and register it as a lease. Pay a tax to the government. Tenancy agreements does not necessarily, 2-year tenancies and so on, do not necessarily have to be registered. Okay? But with respect to a lease, that's tenancies of 3 years and above, you are expected by law to register them in court, in both the court and the Ministry of Lands. Reasons being that at the end of the day, if there are issues and you intend to tender that agreement as evidence in court, the court will not see it because it's not as expected. It's not in the form expected of the lease agreement. Right? So when you go to sign agreements, try and take some of these tips into consideration. Ask some of these questions. Okay? And when you ask them, you have clarity, and that clarity will help you in the long run. If not, those pitfalls will haunt you, both the tenant and the landlord. The landlord has a peculiar situation because he will always be the one to wish to evict the tenant. And when you go to court and raise that document and they tell you you don't have a document before the court, you don't have an agreement before the court to refer. Okay, so we go back. We've identified types of tenancies to include periodic tenancies and also fixed tenancies. What other issues do we have in landlord-tenancy relationship? Some of them are issues of maintaining the property. People come in and say, okay, the lock is spoiled, the water heater the system is not working. Some of those things, if you had an agreement, the agreement would have specified if there is any damage to the property over a certain amount, the landlord will take it. But if there is a damage below a certain amount, then the landlord would, the tenant would have to sort that out. Okay. But you see, sometimes when you have issues is where the property, for instance, I said any damage above 20,000 will be taken care of by the landlord. And there's cumulative damage to the property. The cumulative damage would now mean this is 15,000, the other is 5,000, and there's a third one for 3,600, and the total amount is above the 20,000. How do we split it? Well, my advice has always been the tenant takes all, because none of them is above 20,000. There are pieces of expenditures that accumulates to the above 20,000. Right? The plumbing work is bad, the heating system is bad, and maybe the front gate has questions to answer. So, but when you put them together, they shoot above the threshold of 20,000. And people will always say, yes, the landlord said any cost above this. Identify it properly, not as cost, maybe as expenditure, all right? But that are individual expenses that are all below 20. But if the soakaway is bad and needs a replacement or reconstruction, that's a single unit. And that single unit is above 20,000. Then the landlord takes that. If the roof is leaking and they will need to replace half of the roofing sheets, and that's above 70,000 or thereabout, then the landlord takes it. But if you have your child maybe repaints the house with crayons and water markers, and you tell the landlord, and you want to leave the property, the landlord tells you, please, you have to put it back in the tenantable quality because a new tenant is coming in. Sir, this is your responsibility. Again, the numbers to call is 090-222-31011. I repeat that number, 090-222-31011. The alternative number to call is 070-454-17707. I repeat the alternative number, 070-454-17707. This is Legally Speaking. We're talking law of landlord and tenancy and the rent control laws, especially of Akwa Ibom State. It doesn't matter. Like I said, most of these provisions of the law are universal. Hello, this is Legally Speaking.
Hello, good evening.
Good evening, sir.
Good evening. This is James calling from Ikota Panaria.
Jones from Ikota Panaria. Go on, sir.
Calling from Ikota Panaria.
Yes, sir. I get you right.
Right. I want to find out if one has a tenant that is a monthly tenant What is the duration of the quit notice to be given to him?
Okay, notice to quit. All right. All right. Just for I had said earlier on, if you have a monthly tenant, the notice to quit is 1 month's notice to quit. But you have to be careful. In my line of experience, I've seen things happen. A landlord comes to court and says, my tenant is a monthly tenant because he's been paying monthly rent. No, the law will ask to see the agreement. If there was no agreement, how did he pay at the first entrance to the property? If he came into the property paying 1 year, 6 months, the law sees him as a yearly tenant, even though subsequently he began to pay on a monthly basis. The law still sees him as a yearly tenant. So you have to be careful how you graduate your tenants. A lot of people come thinking that tenants are 1 year tenants, monthly tenants because they've been paying in piecemeals. No, the rent does. Hello, this is Legally Speaking. Okay. Wait, where is he I'm calling from? Where are you calling from, sir?
Then later, he can't pay me. He say we pay the year we expire on the May next year. The second pay. Then he didn't pay me that 50,000 for the first time. Then I go to court. I bring the notice for him for when the year finishes. He should vacate. He didn't vacate. Then I went to court again. I give him another 7 days notice. Now he says he's going to pay. He don't want to leave. So I don't know what must I do.
All right. That's a good question, Mr. Young. Except you didn't tell us where you are calling from. But I presume you are calling from Akwa Ibom. Okay. When a notice to quit has been issued on the tenant, that notice to quit stands. Whether or not he subsequently pays his rent, you can proceed against him on that notice. 5 years down the line, as long as that notice was valid, you can proceed against him with that notice to quit. Okay? Now, I wanted to say that earlier on. If you have a fixed tenancy and that fixed tenancy has expired and you continue to pay rent, the moment that rent expires, you are liable to be evicted within 7 days unless you continue to pay. You can only enjoy the period that you have paid, but you don't have a tenancy agreement running. It's just equity that says, since there is money, you are holding onto my money as rent, you can stay for the period that money runs. That's it. A case we will, if as lawyers we will say Udutola versus Paper Sack, you probably wouldn't know that case, but it happened in Lagos. That's what the Supreme Court decided on that kind of issue. All right. Now, on landlord tenancy issues, there are various aspects of it that we can discuss and that we will be discussing over time on this program. Part of it will be, how do I get my tenant out after I've gotten judgment in court? There's what we call a writ of FIFA. You get a writ of FIFA. If he's owing you, you pack his things to court, auction it, take your money, whatever is left, he goes with it. That's part of what the law has provided for, instead of self-help, because self-help will get you into trouble. Self-help will take you to prison if you don't take your time, and self-help will make the man stay in your property forever because you would have violated the provisions of the law. Whereas if you follow the law has made provisions that can give you your property with ease if you follow it religiously. But you have to follow it religiously. You don't just have to wake up and act up. You have to follow it as the law provides. Give 7 days, you give 7 days. Give 14 days, you give 14 days. Give 6 months, but he must have notice of your intention to recover that property. Outside that, you can waste all the time you want to waste in court. At the end of the day, the law will say you were not entitled to recover possession. And after spending so much time in court, you will not be entitled to anything. You only go back and try to recover your rent and hope that in the end, or at the end of the day, you will be able to at least have a soft or safe landing. Anyway, that should be the size of Legally Speaking for today. It's been quite interesting running solo with you. Unfortunately, my guests, due to unforeseen circumstances, which in our place we used to call unforeseen circumstances, could not join us. But I think it's been fair enough. And we will see you again same time next week. All things being equal, probably with my guests. My name is Anthony Ebuk. Until same time next week, I believe everything you do will be legal.